Are not yet present. Council wanted to be heard on something.
Yes, Your Honor. I was handed a new stack of exhibits this morning, and several of those exhibits are not information or exhibits that had previously been turned over for this particular expert. And in particular, I have an issue with an exhibit that this accountant created called The Flow of Money Surrounding Project Paul Mitchell. There are several boxes and things that are contained within this exhibit that are complete and utter hearsay and speculation. There are statements in here stating that the defendant is in New York during a period of time because there was a transfer to a bank in New York. There are leaps in this particular exhibit that should not be, this particular expert should not be permitted to testify to. In addition, I have concerns about a Sanchez issue because there are numerous pages of exhibits where there were different charts and things like that that were done, and I don't think that this particular expert created every one of those charts.
Mr. Moran?
Okay, so I'll address the charts part of it. Mr. Sjogren has either directly prepared each exhibit or worked with his son to prepare each and every exhibit, and so I'm not sure what council's talking about in that regard. As far as the flow, the specific exhibit regarding flow of money surrounding projects, that is based on whatever records he reviewed. All of the records are already in evidence. For example, the Charles Merritt in New York part, that was when there was a wire transfer of $4,900, sorry, $6,000 that was sent, and it shows on the wire transfer that it was sent from New York, that he sent it from New York. So, I mean, the idea is not that he's in New York. It doesn't, I mean, that's what the wire transfer indicates, that it's sent from New York, okay? That's why that part of it says New York.
It says specifically Charles Merritt is in New York.
Well, their own witness testified that it was sent from New York, so that's where it was sent from.
The wire transfer is in evidence?
The wire transfer is in evidence, yes.
Okay. And why wasn't all of this provided well before the witness testified?
I got all these and all these exhibits, by the way, they are, most of it is extrapolation from the large report with exhibits, which is 150 plus pages. These are extrapolations from there so that the testimony will flow easier, and we don't have to sort through 150 pages every time there's a reference to Saudi Arabia money or whatever. It's just narrowing what they already have for the most part.
Let me see the exhibit.
They're right there.
The exhibits.
There's one other thing, Your Honor, with respect to the bank records from Dan Kavanaugh that the court should have a copy of, I believe, as well. However, the foundation for these particular exhibits is lacking.
And therefore, any expert testimony based on those lacks foundation.
All right, well, Mr. Kavanaugh's bank records are in evidence, right?
No.
They are not, Your Honor.
We believe they are, Your Honor. We have it marked on our notes as being already admitted, but I also have the declaration from Bank of America along with the, when we have the records. It's Exhibit 438.
Let me look at these first. Okay, so several witnesses have been utilizing bank records and Joseph McStay's records to document various transactions and flow of money, checks written, checks cashed. So certainly the defense is entitled to have their witness look through those same records and offer his opinion as to what they show. With regard to Kavanaugh's bank records, we have had the bank records, computer records, PayPal records of various individuals, obtained phone records, extensive phone records, obtained by way of subpoena DT, and they have been utilized. I understand the people's objection with regard to the Kavanaugh bank records, the original affidavit accompanying those records was separated from the records. But apparently you now have a new affidavit.
Well, it's the same affidavit that's been previously marked, but it's a, I believe it's 950, but it's for the records. They were, as the court mentioned, I have a copy of the actual affidavit. But the affidavit itself, I noticed, is in with the records as well. It's in both places, so.
Your Honor, that's actually not the issue. The issue is that the exhibits were removed from court's custody without a stipulation as to chain. Second, the affidavit was not signed and declared under penalty of perjury in the state of California, and that is not clear from its face considering the notary was in the state of Arizona at the time. Therefore, there's been no foundation laid for those records.
The relevant code section there is Code of Civil Procedure 915.5.
I'm satisfied that the documents are Mr. Kavanaugh's bank records, and there's been references to money either coming into or out of, or going to Mr. Kavanaugh, or basically money going to Mr. Kavanaugh. So I think the expert is entitled to rely on those documents to offer opinions about monies coming into or out of Kavanaugh's account. So in looking at these records or these exhibits, so we have exhibit 1115.
I'm not sure what that one is, Your Honor.
It is flow of money surrounding Project Saudi Arabia.
Okay. The main one that I have an objection to.
I know, I'm getting to it.
Okay.
Right? So exhibit 1115, flow of money surrounding Project Saudi Arabia. And then 1116, schedule of account fees from Charles Merritt Bank of America account ending 2519, 2310 through 51210. And 1117, looks like it's really just a continuation of the last one. Schedule of chargebacks from Charles Merritt Bank of America account 2519, 2310 to 51210. And 1118, schedule of deposits into Charles Merritt Bank of America account 2519, 2310 to 51210. 1119, schedule of purchases from Charles Merritt Bank of America account ending 2519, 2310 through 51210. And 1120, schedule of transfers from Charles Merritt Bank of America account ending 2519, 2310 to 51210. And 1121, schedule of withdrawals from Charles Merritt Bank of America account ending 2519, 2310 to 51210. And 1122, schedule of withdrawals, transfer and account fees from Charles Merritt Bank of America account ending 2519, 2310 to 51210. And 1124, schedule of amounts paid to and owed demerit from McStay ledger, 11/7/2008 through 1/28/2010. And 1125, Charles Merritt, percentage of revenues per job from McStay ledger, 2007 to 2009. I don't see a problem with those. I think those can be utilized by the defense expert. Exhibit 1114 is schedule of Daniel Kavanaugh Bank and PayPal accounts combined spending, 2/10/2010 through 12/23/2010. Subset business further broken down. That one appears to me to be overbroad. The court had indicated any financial transactions dealing with between Kavanaugh and Earth Inspired Products and McStay and Merritt would be relevant. But other overall spending of Kavanaugh, whatever he happens to spend his money on, isn't particularly relevant, I don't think.
Your Honor, just to clarify that, so the court's aware, the money that is reflected in that exhibit and the overall exhibit that's part of the original report, this is money that came into Dan Kavanaugh's account as Earth Inspired Products when he took over the business. There's no other money that came in to those accounts other than Earth Inspired Products money, meaning customers ordering fountains online or the few custom orders that he received. There's no other income or source.
This says this is spending, not income.
Correct, so the money that came in, so the spending that is associated with all that money that came in. Some of it was business expense, some of it was personal, some of it was whatever. But whatever the money was spent on, it all came in as Earth Inspired Products money.
Well, I have no problem, and I think all of the other exhibits tend to show money coming into Kavanaugh's account from either McStay or Earth Inspired Products. I don't have a problem with that. But what Kavanaugh then does with that money doesn't have any relevance.
Well, what if he doesn't, when he gets a prepaid order, which is how they buy the fountains online, they give their credit card or they give their PayPal account, and so they send the money to Kavanaugh for Earth Inspired Products for, let's say, $1,000. What Earth Inspired Products does then, what Joseph did and what Dan Kavanaugh was supposed to do is then turn around and go buy a fountain so that it can be sent to the customer. So you get $1,000 in, you go to one of the firms, Adagio is one, a big one that they used, and they spend $500 buying it, and then that fountain is shipped to the customer, and they made a $500 profit. The problem with Mr. Kavanaugh is he took in the money, the $1,000, but he never, in most cases, an overwhelming amount of the cases, never purchased a waterfall to send to the customer. Hence the sale of the company, hence the debt, hence the lawsuits, hence all the rest of the things that occurred. But the bottom line is, he never, 25% of that gross revenue was used to purchase fountains. And that's a very small percentage. And he left many customers without their fountains when they had prepaid them. And so the personal spending just breaks it down. So we can see how much was spent on business, how much was spent personally, and how much was ATM cash withdrawals and so forth.
Well, I think I don't have a problem with you showing if in fact Kavanaugh received money and there's evidence that he was then supposed to buy supplies, fountains, whatever, and he didn't. That's fine. but where he did spend his money isn't particularly relevant.
We're not gonna we quite frankly don't, it's not important to us where like if he went to a nightclub or he went to a hotel or whatever, that really doesn't concern us. It's the totals that concern us. Mr. Sjogren prepared schedules because that's what accountants do, but we certainly don't have to go into the individual. I assure you that we're not going to go into the individual places that were visited for personal spending. It's the totals that matter to us.
The other issue I have with that is the assertion of how many orders came in versus how many were fulfilled. There's no foundation for that. There's no evidence of that. They've proffered no witnesses as to uncompleted orders.
Well, they're in the records, and that's what his job
The
is.
records simply show a transaction. They don't show whether or not it was completed or not.
Well, I mean, even, this document shows. I think this document is overbroad. I think you can have your witness say, he received X amount of dollars from Earth-inspired products, and he only expended Z amount of dollars, for supplies and fulfilling orders. And,
Okay, that's fine.
So I would sustain the objection to 1114 as overbroad and relevancy evidence to 352. On exhibit 1123, which is entitled Flow of Money Surrounding Project Paul Mitchell, that's the one that has the statement Charles Merritt is in New York. The rest of the exhibit just indicates flow of funds. There's an invoice, there's a deposit, there's payments. So I think the statement in box number 9, Charles Merritt is in New York, and then the information to the right of that, shipping address for Mitchell Construction is in New York. This information found in Charles Merritt bank account ending 2519 and Earth-inspired products, copy, such and such, invoice, such and such. I think that needs to be taken out of the exhibit.
We also would object to box 8 and box 10, Your Honor. Box 8 is a payment or a proposed payment or supposed payment to Metro Sheet Metal, and all that they're utilizing to make that leap is the fact that the defendant took out $4,900 from his bank account. There's no evidence that he paid that money to Metro Sheet Metal.
Except for the fact that it's on the...
If I could finish, and in box number 10, there's a withdrawal for $3,600, and there's no information that that was paid to Metro Sheet Metal. So this assumption that those monies were actually used for the Paul Mitchell project is pure speculation.
Well, if an accountant says he's reviewed that and his conclusion is that it was for that purpose, and he's coordinating it with other documents and expenditures, I think he can offer that opinion. He's certainly subject to cross-examination on that issue, and I think that goes to weight, not admissibility.
Actually, it's probably based on hearsay. We'd ask for an offer of proof of what it's based upon outside the presence of the jury, because it seems quite subjective state of mind evidence, not something that would be borne out in a bank record, since it's a cash withdrawal.
And I would add that the Metro Sheet Metal statement that was dated March 1st, the witnesses that testified and were asked about that exhibit said they had no knowledge about it, so it's not anything that's actually in evidence.
Well, counsel forgets Carmen Garcia's testimony. She verified that statement, and the $4,900 payment that was withdrawn is on that statement as paid.
I would beg to differ with respect to what Ms. Garcia's testimony was. She specifically said she did not create invoices.
It's not an invoice, it's a statement, and she did verify it.
She wasn't even shown it.
Okay.
The witness in the exhibit indicates that it's referencing the Metro Sheet Metal statement dated 3/1/10.
That was shown to Mr. Cicada. He didn't know what it was. It was never used after that. So no foundation was laid for it.
That's correct.
Just because they say it doesn't make it so.
Fine,
I showed
review the transcript.
Don't interrupt me. I'm the one who showed it to Ms. Garcia. She verified it.
No, he did not.
Okay.
All right.
Let's check for the exhibit number and what it was.
When did she testify?
Well, see, this is the problem when you submit exhibits the day the witness is going to be called. We end up spending a day or more litigating what can be utilized.
Your Honor, this is an obstruction tactic. It's nothing more. These are all exhibits that have been admitted, reviewed. They have this
No
information.
exhibits have been admitted.
I'm sorry. The exhibits that they rely on is what I'm talking about.
Yeah.
Specifically, the Metro
Lots
Sheet
of
Metal.
We have almost 1,200 exhibits that have been monitored.
I understand.
I do not recall off the top of my head the precise testimony and foundation for all of those exhibits.
They're doing nothing but obstructing and delaying, and that's their goal to do that, and that's what they're doing. I expect nothing else, and I expected some type of delaying tactic or obstruction tactic, which is exactly what they're doing, and they've done it all along. When we complained about Mr. Weitzman coming in at the last minute with his charts that said gambling all over it, of course, the jury saw all of it, even though we felt that was prejudicial, and the court found no problem with what he had to say, even though it's completely irrelevant to these proceedings.
Actually, Your Honor, those exhibits were turned over days and weeks in advance, not the morning of testimony.
That is not
and
correct.
the 2 inches.
Just a minute.
And the 2 inches.
Just a minute. I know that the defense, every time there's a ruling that looks like it's going to go against them, they want to re-argue other issues that have already been resolved that are different. With regard to the prosecution witness, there was the same or similar objection that it was new information, that they didn't have an opportunity to review it, that there was no report. And we did spend some time with the court going over that. And the court was satisfied that the information that was provided to counsel earlier was in effect the report and what he was going to be testifying to. The court found that the evidence with regard to Mr. Merritt's expenditures and his financial status as a result of those expenditures was relevant. I'm permitting you to have your witness now look at Mr. Merritt's expenditures and offer his opinions and conclusions. But if an accountant or an expert is going to come in and say, Metro Sheet Metal was paid $4,900 and I'm relying on a record from Metro Sheet Metal and nobody laid a foundation for that, then he's not entitled to do that.
All the exhibits, Your Honor, all the backup material, counsel is saying that. I'm not going to argue with them. I showed this personally to Ms. Garcia when she was on the stand. She verified it. So if they're saying it didn't happen, it's incumbent upon them to show that.
Do you know what date that was?
January 31st.
January 31st. I believe that's exhibit 740. I just conducted a search of that transcript.
Okay.
That doesn't exist in the transcript.
have a number at the time, Your Honor.
No, you showed it's David Cicada who testified before Carmen.
Just a minute, let me, Carmen Garcia.
It is exhibit 74.
Seven 38 and 739. Sorry. Yes, it's 740. Here it is.
740? It's not in the transcript.
I don't have it in my notes, but maybe the court reporter can check it with you in the morning, January 31st in the morning. Carmen Garcia, and what's the exhibit number?
740?
I think it was in the afternoon.
It's page
It
35.
started in the morning and it went into the afternoon.
You have the transcript there?
I do.
Yeah, I searched it for exhibit 740, it's not in there. It starts at 3516.
Let me see the transcript. Can I see the transcript?
Oh, sure. It's electronic.
Of course it is.
Starts right there. Scroll. You just use your fingers.
Well, this is just, well. Well, I'm not gonna read all of her testimony, right now.
What part do you want?
Any part where she was showing
Okay.
a particular statement.
I searched for 740. I could search for statement.
I just searched for invoice and statement and found no such showing of a document.
I suppose it would have been on cross. Probably skipped to the cross examination.
Yeah, it definitely, well, yeah, probably.
We revisit these. Cross exams.
Why don't we take a brief recess and I can ask the court reporter to check, see if there's any reference either to exhibit 740 or a Metro sheet metal statement dated 3/1/2010. Okay?
It's in the page, so I have to go get a transcript.
Okay.
I only have my stuff.
Okay.
Only take a second.